Unmute. There we are. Unmute. Morning. Can we all hear me? Give me a nod. Yes, we can. Super duper. Morning, everyone. Hope we're all okay. This morning, I'm just going to do a bit of a webinar around redundancies, but I'm not going to cover perhaps what you might traditionally think I would cover, which is to go through the basics of redundancy and all that sort of stuff. Just because, you know, you're all pretty much seasoned HR people, you all know what you're doing. But there are, of course, some little googlies out there at the moment with respect to redundancy and questions that I think I'm being asked by my clients about, where there's uncertainty around the link between perhaps furlough and redundancies and all of that sort of stuff, you know, payments for notice, all of those sorts of things. So there's little quirky things where we're all not quite sure where we are with it. Those are the things that I'm going to try and tackle for you this morning. So I have had a question in advance of the webinar this morning, which I have addressed yesterday. So hopefully the person who submitted that, it was quite a complex question, but hopefully the person that submitted that has had the response. But if you needed to ask anything else and you're on the webinar, you know, please do submit some more questions and we'll deal with it at the end. So one of the first questions that I'm going to deal with is, can you make redundancies during furlough? Okay. Now, we'll all know that there's a bit of scaremongering around this, and we're going to try and address that during the webinar this morning. But quite frankly, the simple answer is yes, we believe you can. Mainly because we're all aware of the guidance that's been published by the government. And the guidance for employees states that furloughed employees can be made redundant during or after furlough. Furthermore, the guidance for employers, which is obviously slightly different, states that an employee's rights in relation to redundancy are all preserved during the furlough period. So those two intimate that it is possible to proceed with redundancies even if you've got people who have been furloughed. The other question that seems to have been raised is whether or not you can still claim through the scheme for employees that are serving their notice period during furlough. Now, you might think, well, actually, yeah, of course, that's the case, but it hasn't been the case because there's been some questions raised because of the directions and the guidance that have been issued as to whether or not you can do this. And in fact, they've caused quite a lot of concern and confusion. The reason for this is that there was a Treasury direction on the 25th of June. Now, that stated that the purpose of the scheme was to continue or sustain employees in employment. Well, quite obviously, that could be interpreted that if you're not going to be sustaining employees in their employment, then, you know, maybe you shouldn't be accessing the scheme and taking advantage of the contributions from the government. So there was a question as to whether companies should actually stop accessing the scheme if they are contemplating redundancies. That's now been clarified only very recently by HMRC and the Treasury, who have stated that employers can continue to use the scheme during redundancy consultations and statutory notice periods. Now, that in itself then raises other questions because the terminology that's being used is that you can continue to access the scheme during statutory notice periods, but obviously very often contracts will provide for much greater notice. So there's still some uncertainty, I think, around, say, for example, if the statutory notice period for somebody was 2 weeks, but their contract says a month, you'd be obliged to pay a month's notice. But is it the case that you can only access the scheme, therefore, in relation to the 2 weeks statutory notice? Again, we're uncertain. Most companies that I've been working with who have been accessing the scheme have accessed it for the entire notice period. But as I say, there's a question there that I think will need to be clarified going forward. This is a question that I'm being asked an awful lot as we get into more and more of the redundancy processes. So will it be an unfair dismissal if you make an employee redundant when the furlough scheme is still available? Now, I've been advising, there's a specific client of mine that I've been working with who actually was going to proceed with redundancies before Covid-19 hit. They started the process and then very quickly everything got locked down. During that lockdown period where they wanted to continue with the consultation, the employees who were involved in that consultation process all made challenges to the company that they shouldn't be continuing with the process, and in fact they should be furloughing the employees because that will preserve their jobs for longer. Right early on in this whole COVID lockdown with all the furlough scheme, I advised I think it's safest on that occasion to actually cease the process, inform the employees that you're ceasing it only for a temporary period, so that they can be furloughed, and then once the company needs to start the process again, it will do so. And that's what we did. We've only in the last week or so started the process again, but I think in doing that we've preserved the company's position of behaving reasonably in accessing the scheme to try and preserve their job for as long as possible. The problem now with obviously opening up and easing the lockdown is that the company needs various people to now be carrying out roles, which is why we've started to invoke the process again. So back to that question, will it be unfair if you make an employee redundant while the furlough scheme is still available? Well, firstly, of course, we've got to go back to normal law, which is that employees have got to have 2 years service before they can bring an unfair dismissal claim. So the first thing is if you've got anybody with less than 2 years, then that's not going to apply in any event. Whilst redundancy is, of course, one of the 5 fair reasons to dismiss, it still has to be reasonable to dismiss the employee for that reason. And I think the whole furlough argument taints reasonableness and touches on reasonableness in terms of you thinking about how you're going to deal with the redundancies. Obviously, with that example that I gave you of that particular client, I think that those employees were lining up to challenge and bring an argument that if we just ploughed on with the process, they would have pursued claims for unfair dismissal, because the company could have accessed the scheme for a period of time. But fairness obviously depends on all the circumstances of the case, and each case will turn on its own facts. So it's not automatically going to be the case that it's deemed unfair if you do have to make an employee or employees redundant whilst the scheme is still available. One issue that might fall in your favour in that respect, and if somebody did challenge it and the tribunal were looking at whether or not you'd acted reasonably, would be, of course, the changes that are coming into force from the 1st of August to the scheme. So up until the 31st of July, as we know, the government contributes towards employers' NICs, pension payments, covers up to 80% with the cap. We know that from the 1st of August that's going to change, and of course the first obligation will be to pay those employer NICs and the pension payments, and then of course the contributions will increase throughout September and October with a 10 and 20% requirement from the company. So having that in mind, I think if you were to proceed with redundancies on the basis that there will be additional costs to the company from the 1st of August onwards, that may well go towards showing that you've behaved reasonably in waiting until that time to proceed with redundancies. That's just a point that I think the tribunal may take on board. The other thing that you might have to start thinking about is the Chancellor's retention bonus. So I'll talk about this a bit later, because obviously we've had that announcement in the time since I did the last webinar. But of course, that retention bonus again brings into play whether or not the company should be thinking about how that will affect the decisions concerning redundancies, because obviously that scheme, which we'll talk about in a second, is to promote again retention of employees into their employment through until January 2021. So again, if you're thinking about redundancies, part of your deliberations, the notes that you're making, the decisions that are being taken, make sure that you're having regard to that bonus and including that in your considerations when you're deciding whether or not to proceed with the redundancies or not. A key point is that if you were to make redundant somebody who had got more than 2 years service, but they'd not been furloughed before the 10th of June, is that of course they won't be able to rely on the argument of you should have invoked the furlough scheme for me instead of proceeding with the redundancy, because obviously you can't furlough somebody after the 10th of June. So that's another thing. If you're considering a pool of employees who perhaps have not been furloughed, then again that should come into your considerations in thinking, well, they would not be able to pursue that argument. Another of the questions that I'm being asked is what happens post furlough scheme ending? You know, what are our options? Are there other options apart from redundancy? So firstly, obviously this new furlough arrangement has been introduced by the government. In that situation, if the furlough scheme ends at the end of October, one of your options could be that you agree to continue to furlough those employees, i.e. lay them off. And that's in a situation where you haven't got a contractual right to do so. Some contracts will have a layoff and short time working clause in them. If you have those in the contract, then you can invoke those, obviously, but you need to have regard to the statutory scheme about the employee's right to claim a redundancy payment either after being laid off for 4 weeks consecutively or 6 in any 13, 3 of which have to be consecutive. So having regard to that, if you've got a layoff and short time working clause in the contract, you could invoke that. If not, and the employee agrees to continue to be furloughed, that's an option for you. But the problem with that, of course, is that there's no money to access from the government. So even if an employee was furloughed, they're not going to have any pay, you can't access, and I can't see how employees really would want to agree to that unless, of course, they've got some other provisional way of earning income. Employees could agree to a reduction in pay, and that could be a permanent or a temporary reduction. If you haven't got the contractual right under a layoff or short-time working clause to do that, then you could consult with the employees and potentially reach agreements. That's another option. One thing that you need to be aware of is that employees cannot withdraw their consent to be furloughed once they've agreed to a specific period. So having regard to that, think about whether you've already put shorter limits on the period of furlough into correspondence that you've issued to the employees. So you may have said, well, we'll furlough you until the end of July. Have a look at that and see whether it's worthwhile putting a longer extension into that until perhaps the end of October if you need to, just so that it's clear that the employees consented to that period, as they then can't withdraw from it. You could undertake collective consultation to seek to change terms and conditions. But of course, if these alternatives aren't viable, then you would then be in a situation where you may need to consider redundancies. What about the Chancellor's retention scheme, which has been introduced for the post-furlough period? So last week, he announced a job retention bonus as well as other incentives to incentivise employers to keep furloughed employees employed after the end of the scheme on the 31st of October and up until the end of January 2021. For that scheme, employers will receive a one-off bonus of £1,000 for each employee who was previously furloughed and remains employed on the 31st of January. So the first thing you've got to consider is that there has to be permanent employment between the end of October to the end of January to be able to get the bonus. You can't lay people off and then bring them back into the workplace. To qualify, employees have to have earned the lower earnings limit, which is £520 per month, on average between the end of the scheme and up until the end of January 2021. The bonus will be the same. It's a flat rate £1,000 payment regardless of the salary that the employee earns, which means it's more likely to be attractive to those with lower paid employees than those that have higher pay. It also looks as if the bonus can be retained entirely by the company and it does not have to be passed on to the employee. The whole point is for it to be almost like a top-up one-off bonus to the company for keeping the employee on. I understand the payments will start to be made from February 2021. So the only issue with that I can see is that you're going to have to front load pay between the end of October to the end of January to then get the benefit of receiving the bonuses from February onwards, which again, that could be something that companies are unable to meet during that period. It also seems to be the case that those bonuses will be paid regardless of whether employees are at risk of redundancy or not. So it simply is to any company that retains an employee who was previously furloughed between the end of October until the end of January. Doesn't apply to those employees who've not been retained but not been furloughed. So if you have retained an employee in employment but you've not furloughed them, that's somebody that you would not get a bonus payment for. So as I've said to you, because of that bonus scheme, because of the way that works, you will need to factor that into your considerations in terms of what value and money that would bring into the company when you're thinking about redundancies going forward. The other key thing that you'll need to think about is selection pools. So for example, if you were to choose only employees that had not been furloughed in a selection pool to be made redundant because you're not going to get the bonus for them, that's probably going to result in a potential unfair dismissal claim and a potential challenge to the decision that's been taken. So again, just have regard to that when you're thinking about your selection pools. So turning again to redundancy. Can you still consult during furlough? Well, yes, of course you can. You can still carry out both individual and collective redundancy consultations during the furlough period, but obviously there's going to be issues that are relevant. So can you still access the scheme to claim the grant if you intend to make redundancies and you're consulting during furlough? We've addressed that, and yes, you can. The second one is, does the consultation count towards working, which is obviously prohibited under the scheme, which may affect your ability to access the grant if it's deemed an employee's been working. As consultation does not involve an employee making money for the employer or providing services, then it's arguable that the consultation is allowed and would not be deemed to be working. Can you carry out collective consultation without breaching furlough? So the guidance for employers explicitly states that employee representatives may undertake duties and activities required of them during individual and collective consultation. And this will not be considered to be work for the employer, thus supporting the argument that consultation can take place during furlough. What about practical issues with the consultation whilst the employees are on furlough or remote working? Obviously, this can be a challenge because normally we would do meetings face-to-face, and normally those face-to-face meetings have been vital. So flexible furlough can make it easier because obviously if you've got flexible furlough, you'll be able to bring employees back to work, and whilst in the periods that they're working, you can undertake any consultations that may be necessary. Obviously, they'd be paid for those periods that they need to return. It's likely that virtual or remote consultation will still be required for those who've not returned to the workplace. If you require employees who are furloughed to attend the workplace for meetings, then given the flexible furlough scheme, as I've said, you will need to pay them for those periods. You'll need to consider logistics and arrangements to ensure that technology facilitates the meetings between the company and, of course, any representatives that take place during those meetings, whether it's trade union representatives or whether elected employee representatives. If it's not possible for meetings to take place remotely, then you may have to conduct those meetings face-to-face in the workplace, in which case you'll have need to have thought about and given consideration to social distancing measures, undertaking risk assessments before those meetings take place, and of course providing PPE as appropriate. For collective consultation, you might need to think about doing remote ballots. You might need to use a third party for doing virtual ballots if that's possible. What you need to do, though, is to take all the steps that you possibly can to inform and consult. I don't think any tribunal is going to say to you, well, it was okay that you didn't do proper collective information and consultation with employee representatives or trade unions because it was difficult to do so due to COVID-19. That means I don't think you'd be able to run the special circumstances defence, which means that you don't have to do those things, if you haven't taken steps to try and comply. Certainly, as a minimum, you'd have to be consulting with employee reps or trade union reps at the initial stage to make sure that there's been some form of meaningful consultation before you moved on to make redundancies, even if those redundancies were urgent. If you don't, if you don't do that and you can't successfully run your special circumstances defence, and you're looking at a protective award being made for each employee, which of course is up to a minimum 90 days uncapped pay, which obviously can be very expensive for the company. So you'll need to think about other things, such as how you can keep in contact with the employee and agree the format for the entire consultation process. It's helpful if at the beginning of the process you say all the consultation meetings will be virtual, if the employee can do that, or whether they'll be by telephone, or whether they are going to be face-to-face, and what measures will be agreed to ensure that the employee feels comfortable with that. You may need to use telephone instead of computer facilities, depending on what the employee has by way of electronic or other software available. Consider how the right of accompaniment can be facilitated, because that'd be quite difficult if you're doing remote meetings but other people haven't got the ability to remote into those meetings, and on that basis you may need to consider reasonable adjustments. So although the statutory right is to be accompanied by a fellow worker or a trade union representative, you may need to give consideration to allowing family members or friends to attend during those meetings so that the person has a right of accompaniment. And I think the tribunal again would see that as being reasonable due to COVID-19. Think about translation of documents. If you have a workforce where language may be a barrier, you need to think about how you're going to conduct those meetings, whether that needs to be that you engage a virtual third party to interpret, or you'll have a face-to-face meeting where an interpreter will be there, or whether you translate all of the documents. So just give consideration to that as the normal steps that you would take. Of course, you need to deal with the issue around recording of any meetings. We've had the case law, haven't we, around covert recording. As with any meeting, make sure that's addressed, although of course it's quite difficult, or going to be quite difficult, to ascertain whether somebody's recording the meeting if it's of course being done virtually. Just moving on finally then to things such as notice pay and redundancy, because there seems to be a lot of questions around what you've got to pay for notice, whether it's full pay, whether it's furlough rate, and we just want to try and work through some of those queries, and I'm certainly getting a lot of questions about this. So firstly, the redundancy, the statutory redundancy payment, or of course any contractual redundancy payment. You cannot claim any statutory redundancy payment through the scheme. So any redundancies that you're going to make, the company will need to foot the bill for any statutory redundancies. And that goes, of course, for any contractual redundancies if you have in place any sort of enhanced redundancy scheme which provides for a contractual sum on top of the statutory amount. You cannot claim any enhanced payments through the scheme. So, for example, with some of the clients that I've been working with, they've been putting settlement agreements in place with respect to terminations connected to redundancy, and very often those will result in an enhanced payment. It could be the case as well that you've gone out for voluntary redundancies, and in those voluntary redundancy packages, you're offering an enhanced payment, subject, of course, to a settlement agreement. You cannot claim those enhanced payments through the scheme either. Now, how do we calculate the redundancy payment? I've had questions around, do I calculate the statutory redundancy payment on the basis of the furlough pay, or is it on the basis of the full pay? Well, during the furlough period, an employer's hours of work will not change. So if somebody's completely furloughed, we know their hours of work don't change because they're actually not able to work and they are preserved. In that situation, you'll be required to make any statutory redundancy payments based on a week's pay, which is based on their full pay rate, not on the furlough rate. So that clarifies that question. Notice, however, seems to be a little bit more complex. So we know that you can continue to claim notice through the scheme, or of the proportion from the government towards notice, if you've got to pay full notice pay. But we need to work out who it is that's entitled to what type of pay for the notice period. So firstly, payment in lieu of notice. I've been asked lots of questions around payment in lieu of notice where it is a redundancy, where somebody's been furloughed. Firstly, a payment in lieu of notice cannot be claimed. So if you decide to make a pile-on payment and terminate the employee's employment immediately, you're not going to be able to access the scheme for the amount of the money that would have been due as a contribution towards the weeks of notice, if that makes sense. You have to have the employee continuing in employment through the notice period, being furloughed, for you to be able to continue to access the scheme on a 3 weekly basis. In any event, most contracts of employment will say that where you make a payment in lieu of notice, that payment is for basic pay. So if from a contractual point of view, as well as a statutory point of view, if you were to say, well, we're going to make a payment in lieu of notice, but we're going to pay it at the furlough rate, not only would you probably be looking at a potential unfair dismissal claim, but breach of contract claim, because they will say, well, in circumstances where you have the discretionary right to invoke the contract and make a payment in lieu of notice, that says it has to be my basic pay. So again, I think that has to be at full pay rate rather than pre-furlough rate. So when can you pay notice at the furlough rate? If the employees, this is complex, so this is the same situation as where you've got an employee who's off sick, and this provision is provided for under the Employment Rights Act. If the employee's contractual notice period is at least 1 week more than the statutory minimum, then they can be paid their notice at their furlough rate for all of the weeks of the notice which fall within the furlough period. So just go over that again. If an employee's contractual notice period is at least 1 week more than the statutory minimum, so for example, if you had somebody who was entitled to 2 weeks notice, but contractually a month, well, that's more than 1 week more than the statutory amount, then for their notice period, arguably, that could be paid at the furlough rate and not at the full rate. Secondly, if an employee requests to be furloughed, so let's say, for example, which is happening quite a lot, and I'm dealing with quite a lot of these sorts of questions, you're opening up for business, you're expanding, you've got your social measures in place, you've got your PPE in place, and you want to get people back to work, but people are saying, actually, I can't come back to work because the children aren't at school and I need to look after them. in that situation where they're asking to be furloughed, there's an argument that they should only be paid any notice entitlement at the furlough rate of pay if their employment is subsequently terminated. And the reason for that is because they're not actually ready and willing to work. However, for those furloughed by the employer, so people that you have furloughed, and or for those people who are unable to work due to sickness or family leave, etc., and those whose contractual notice period is less than the statutory minimum plus 6 days, the employee's notice period will be likely to have to be paid at full rate, not at pre-furlough pay. Sorry, at pre-furlough pay and not at the furlough rate. So the explanation for that is if the employee is ready and willing to work, but not provided with work by the employer, then these types of special provisions will apply. They'll apply where an employer has asked an employee to agree to be furloughed. They don't apply where the employee themselves is asked to be furloughed. Those who fall within the scope of the protection are entitled to a statutory week's pay during their notice period, which means they're entitled to their pre-furlough pay. But how do you calculate that? For those on a fixed rate or salary, the statutory week's pay is a normal week's pay, so that should be quite clear in terms of what you need to pay. A week's pay is based on normal working hours, which is why it's not based on the furlough rate, and it's based on the pre-furlough rate. As no work is carried out during furlough, normal working hours and pay will be based on the pre-furlough position. For those with normal working hours whose pay varies, a statutory week's pay is calculated on an average of the previous 12 working weeks. As no work is carried out during furlough, this has to be based on the pre-furlough weeks. It has to therefore be based on the full rate. For those who do not have any normal working hours, a statutory week's pay is based on their pay over the previous 12 weeks. And in this situation, you're likely to need to top up the notice pay to full pay. It'll still be the case that you'll be able to use the scheme to recover part of the notice pay. For those on flexible furlough, it's arguable that again, any notice pay would need to be paid at their pre-furlough rate. Finally, holiday pay, because of course that's also payable if an employee's employment is terminated by reason of redundancy. It's firmly established that where you're making payments for holiday, either during furlough or if they're paid in lieu for that holiday after furlough, it would have to be paid at the full rate, i.e. the pre-furlough rate. And that brings to a close all of the quirky points that I wanted to deal with around redundancies and COVID and furlough. It's over to you with any questions that anybody's got. I'm more than happy to take.
Thank you, Sally. There's already been a few questions in the group chat, so I'm just sort of scanning through those now. But now is the time to pop any questions into that area if you can, and I will read them out and Sally will do her best to answer them. So first one then. Do we know as of yet if the retention bonus is only applicable if people have stayed on their current contracted hours, or could we invoke short-time working or consider job sharing?
I don't think we've had that clarified yet. At the moment, it simply is that the person has to be retained throughout the entire period. So, for example, if you introduce short-time working, they would still remain in employment for the entire period, albeit their hours and pay may be adjusted downwards slightly. There's no guidance on that as yet, but given that the overarching comment that's been made is that it's about retaining people in employment, there's an argument that you would still be entitled to the bonus for that reason. I think we need further clarification on that point.
Okay, thank you. Next question, if people are furloughed and being made redundant, must we pay 100% or 80% for their notice period?
I think we've just gone through that, haven't we? That will depend on, and I'm happy for that question to go offline if that person wants to ask the specific question that relates to their employees. Whether you pay the pre-furlough rate or the furlough rate will very much depend on who's placed the employee on furlough and what their entitlements are under their contract with respect to notice. So I'm happy to take that one offline if you want to do that, or if you want to ping the question in now and say what notice entitlement they're entitled to, I can address it now for you.
Okay, next question. There was the national minimum wage increase during furlough. So would the notice pay be their pre-furlough rate or the new national minimum wage?
Again, that depends on what notice entitlement they're entitled to. But if it is at full rate, it will have to have regard to the April change and the increase.
Okay. No more questions in the chat area. Has anyone else got anything they want to raise or have Sally clarify a little bit further? Now is the time to do so. I know it can take a little minute for actually people to type. I'm just going to put everyone on gallery view. If you want to, if anyone wants to unmute themselves to ask a question, then feel free to do that as well. So I know sometimes these questions aren't straightforward and it's actually a little bit easier to talk them through. Anyone got anything they want to raise? Everyone happy? Okay, cool. Any final bits from you, Sally?
Well, hopefully that's just clarified a few of the quirky things that have been bounding around things like notice, things like you know, how you deal with the scheme whilst people are on notice, what your limitations are around accessing the scheme. So hopefully that's clarified some of those. Obviously I'll do any updates that anybody wants once we've got further flesh on the bones for the job retention scheme. And if you've got any questions that you want to fire in offline, please feel free to do so, and I'll deal with them for you, no problem.
Perfect. Well, thank you very much. Thank you, Sally, for sharing all of that with us.